Kai LLC for public access purposes. The easements will provide vehicular public access parking, and a Kohala Kai and lateral walkable trail to the shoreline. Reference communication 243 introduced by Ms. Poindexter, postponed July 23rd, 2013, December 3rd, 2013. Note, there is a pending motion by Mr. Nishi and duly seconded by Mr. Kanuha to recommend adoption of resolution 140-13.
Any discussion? Councilmember Lee?
You say at the last meeting we discussed key issues being where the easement should be located, whether it should be on the traditional Alaloa Trail or on this fisherman's trail right along the edge of the shoreline trail. And also in terms of the safety of the Kohala Kai Trail, and the parking was also brought up where it's located. You have to walk, I think it's 360 feet along the highway edge. I think the principal focus was really where the trail was and safety issues, and I tried to focus on those safety issues and seeing if one could expand that shoreline trail and address that, and maybe leave the Alaloa for another day, or basically dump that issue. But the more I looked into it, and I think I had Dave from my office walk last Friday with members of the community. The realtor for the developer was there, the developers were not available, and the planning department wasn't available. I really did want the planning department to participate in this, but they were not available at that time. It's since the last meeting. Basically, the trail, shoreline trail, is very well. It's uneven footing, and it's right on the edge, and some of it is already eroded. And if you're an agile fisherman, it's fine. And if that's what we want to approve, that's what we would do. But I tried to do, can we do another 20 feet? And I'm just looking at it on paper, you know, well, what might work, and can we do it on paper? And basically, what Dave, who went over it carefully, said, well, move it 10 feet, 20, 30. We're sort of, in some places it's okay, in some places it's not. But really, you get to the point where it should be on the Alaloa Trail. As I see it going back at sort of a process level, maybe I could call Larry Brown up. You were working on this, and yeah, and maybe director too. If you want to come up with this. Is that in January the director walked with Belper and Department of the Interior and others, and I know that there were a lot of questions. I think that was actually brought up that January meeting, that the trail was constructed before the plan was submitted, and that was initially being triggered as whether the trail had been put in prior to its approval. I just want you to, is that what the situation was? It appeared that that's what happened, that their input is, at least from the Department of Interior, is that really should be on the Alaloa Trail. And then following that, the planning director approved its location, or doing a seaside shoreline location, and did not go along with the input, say, from the Federal Department of Interior, National Parks, that put it on the Alaloa Trail. So that seems to be the point where I see immediate, where the planning director said, okay, this is a go-ahead, and did not consult with OHA, did not at least listen to the Department of Interior, and did not really reckon with the CDP subcommittees on that. So I just want to get a little understanding of that January meeting to then the next time the planning director walked by herself with them, I had gave her approval to that C-supply location. And let me just say, at this point, I tried to do how can we compromise, and I just don't see that there's any way.
Can I ask them to answer the
okay.
questions, and then
Yes, go ahead.
you'll
Yeah.
still have the floor.
Yeah.
So I heard several questions in there, and I think
So
one of the
comment.
questions is about one of the, you wanna like
Yeah, I'm
address
good.
on the CDP or?
No, just that, from the January, this past January, where I think it was, you were going to go and then you did not go, and that BJ went there, and then it was, the trail was in place, and after that,
Okay. So, do you wanna, who wants to go?
I'll do that, Larry.
Larry? Okay, go ahead.
Essentially, that sounds pretty close to being correct. It was January 2012.
31st.
Yeah, the previous planning director came along on a site inspection of the property. It was scheduled pursuant to a complaint that we got about trail construction being implemented without any plan having been approved yet. And you're correct, I was not able to go. I was scheduled to go, but I didn't go. And so the previous director was there, another member of the planning department staff was there, members of Kohala Kai were there, the National Historic Trail Program, and I believe, I'm not sure, I can't recall, but I think we did invite SHPD representative to be there, and from Kohala, the State Historic Trails Program, and of course the landowners were there. And as I understand it, the director did essentially approve the trail alignments and construction that had been done already at that time with some modifications.
Right. Okay, so I just want to, I mean, my feeling is that was wrong, what was done, and it should not have been approved, and I want to know, in your opinion, how we would correct that at this time. I mean, just in terms of process, I mean, I feel this was the role of the planning director, not the current one, abdicated their responsibility in terms of how this was handled. And so I just, want to know what, I sort of feel like throw it back to you all. I tried to look at if there was a way to handle it.
Okay, so the question.
But that's the question. How do you think this should be, where it was, the procedure was not handled properly in terms of this approval? How we would correct that? What is the process?
Going to the planning director. Well, not normally, anyway, every decision made by the department, which is actually the director, is subject to an appeal. And each of those actions, depending on what they are, have different appeal periods. So, obviously that decision, which was made in 2012, was not appealed. It's way past that appellate period. So, unless there's some kind of litigation involved to correct what you feel may have been an erroneous decision,
I guess I was looking to you. Do you feel that this is something that you as a department would want to try to correct? I guess you're saying no, is you would know that you stand by this even if it's unsafe, and even if the county would be there for libel for whatever accidents might occur, and even though the maintenance would now be on us rather than if it was on the Alaloa, that would put the burden over on Department of Interior, who would maintain it and would have the liability for the trail. So I was just trying to see if you would be willing to rise to the occasion we're going to get this worked out. So
Okay, so and then I'm going to allow him to answer the question. And then I'm going to
That's
move
right.
on, because that was your time. So I don't know if you got a question out of that, or do you need clarification what the question is?
Well, there's a couple of questions in there, but first of all, what's come up is what was placed before us. As you know, the applicant was willing to go meet with the community to try and come up with other alternatives, and at the end of that process, they decided that what they had been granted, what they had been granted approval for, was what they wanted to move forward with. So it's basically before the council. I mean, it's your call whether to to accept what is being presented to you, and if you have concerns relative to that it may be unsafe, there may be some liability to the county, there may be some maintenance issues, that's your decision. Let me roll that back a bit. The way the conditions read, they have to submit this grant of easement to the County of Hawaii. If you decline to approve this easement, if you disapprove it, I would have to go back and look at it, but it could mean that the permit which had this condition may not be valid anymore. And if that's the case, then it could mean that the subdivision application that's related to this permit may not be valid anymore. But you have to remember that this project was done in two parts. Okay, so the first subdivision is already approved, it's already through. This trail, is a component of that subdivision. So the end result would be that the second part, this remaining lot that they're trying to subdivide, could not be subdivided. So you'd end up with a big remaining lot with no public access at all. Right?
Councilmember Onishi?
Thank you, Madam Chair. Director, did you get communication 343.27?
What
The letter to you from Mr. Lim,
is that the one dated yesterday?
December 16th, yes.
Yes, sir.
Okay. And did you look it over?
Yes, we did. Actually, we requested the applicants to provide us with an amended document.
And then on page number 4, it states one of the whereases, third whereas, that they're agreeing to widen easement public access from 10 feet to 20 feet. Right. How do you feel about that? Like there.
Well, our position has been that, and actually it's in this document, it's worded in this document, is that if there's erosion of a shoreline trail that's close to the trail, then it's incumbent to be relocated Malcolm, anyway.
And that's what
All this does is it specifies that wherever it is, there's a wider corridor within which that could happen.
And then, I guess my next thing would be, after listening to testimony, do you think that we're talking about two different fruits, like an apple and an orange, because of this trail? Because of what the applicant is obligated to do, and what the testimony that we're hearing about the Ala trail?
Well, I think that's related to this document here as well. Because in the original document that came up to you, there was language in there whereby if you approve or you accepted this easement, it waived any claims that they would have had to do related to the Kohala Kai or the Alaloa. And our position was, if you claim you have no ownership in that trail, why are you asking for this waiver as part of this approval? So that's the main reason this is up here. We had them delete that language.
And so that's
We did
where,
that language.
on page 7 of that document that was sent to you, number 4, does that satisfy the
Correct.
that satisfies the department and that
Right.
claims?
We just didn't want any waiver related to the Alaloa or the Kohala Kai. Because this goes back to their original, their original title. Somewhere in 1936, the state waived their claim to this trail in exchange for enough land to construct the Aponifuni Highway. There's a number of private properties along that stretch that accomplished that.
So would you be
that
able
kind
to
of
read
trade.
number 4 for the public?
I beg pardon?
Could you read number 4 for the public? That was the letter that was sent to you.
The grantor and grantee further agree that the grantee's acceptance of this grant of public access easements is without prejudice to any existing rights to the ownership or use of the historical Alaloa alignment within the property.
So that would help with this written in here, this agreement, whatever testimony that we've been hearing about the trail. That, could I interpret that's what it means? That this would say that we're talking about two separate issues? Okay, thank you.
Okay, Councilmember Ford?
Thank you. I'd like to call Mr. Yoshida up. I'm calling Mr. Yoshida up. Mr. Yoshida, would you please identify yourself?
Good afternoon, Lincoln Ashita, Corporation Counsel.
Have you seen this clause number 4 that's on this document?
No.
Okay, while the staff is getting this down to the same look at it, there was a discussion earlier about the statute of limitations or something, the appeal period for this SMA, and planning director believed that because it was in 2012 that the period for appeal is gone. What is the period of appeal for something like an SMA, minor, major, or any of the other permitting processes that might have taken place in 2012?
The statute of limitations, or period of limitations, is as provided for generally by rule, court order, or some other. If what you're asking is the period of time that Mr. Kanuha referred to, that's accurate.
It's extinguished?
I'm sorry?
He said it was extinguished if all of this permitting and everything was done in 2012, and is that true? Is that correct? He's not saying anything untruthful. Is it accurate that
Well, Mr. Bilhanti actually should be here answering, because he's taking care of.
That's fine, he's a nice guy too.
Yeah, he's taking care of this matter. If
I don't mind if you refer to him.
okay, sure.
Okay, please identify yourself.
Good afternoon, William Brahanti, Deputy Corporation Counsel.
So the community is really concerned about making an appeal. At least they have made those comments to me. So what is the appeal period from whatever date? And I don't know what the date is in 2012, but it's been implied that the appeal period has passed. It's been less than, this is December, less than 2 years. And I thought appeal periods ran a lot longer than that. So what is the appeal period on permits and stuff that were perhaps provided in 2012?
So generally, when it comes to a permit like SMA minor or SMA major, the language codified in the code is that a member of the public or somebody who is adversely affected by the director's final determination has 30 days to submit a request for an appeal to the Board of Appeals, and that's generally the process.
To the Board of Appeal, but what about the courts?
I think generally, you have to extinguish your administrative remedies first, which means that you cannot just jump straight to file suit, because what the court will do will generally dismiss the case for failure to exhaust your administrative remedies.
Okay, but we're beyond the time period for administrative penalties, or remedies, excuse me, at this point. We can't turn back the clock, so what do we do at this point?
What do we do?
We, generically, the public.
Well, they would have to confer with, their attorney to decide what remedies are available to them, whether there are any equitable remedies, that would ask for leave of the court to allow them to file. I don't know what happened in this particular case. I'm just answering your questions generally in terms of broad strokes, in terms of the requirements of the law. But generally, any party so aggrieved, we would always urge them to consult their private attorney. They're in a better position to advise them as to what remedies are out there.
Mr. Shida, would you explain to the council what the difference is between the council being sued in its official capacity or as a body versus and each of us being sued in our individual capacity as a council member? We are a body of a council, but we're also individuals. So there's a difference between those two things. Would you explain that, please?
It really doesn't matter whether you're talking about a council member or any government officer, employee. Generally, only the county can be sued as an entity. And even if you're named in your official capacity, the county generally will represent and indemnify you for acts which were committed within the course and scope of your duties. It doesn't matter if you're talking about a council member, department head, white collar, blue collar worker. Anybody can be sued in their individual capacity. That allegation essentially is that
they were outside the scope of their
well,
authority.
put in their most simplest terms. You weren't doing what you were supposed to be doing when you were supposed to be doing it.
I understand. But so, as an example, I'm just making this up. If one of us or all of us were sued in our individual capacities, we would not be represented by the Corporation Council, and we would need to hire our own attorney to find out what to do.
That's not true.
Excuse
Okay,
me,
please
Madam Chair. I don't know what this suits about the council members has to pertain to this issue we're talking about.
Excuse me, we've been threatened with lawsuits.
I haven't heard it.
Well, you maybe or Carol.
Okay, so maybe let's bring us back to
All right.
directed questions regarding the trail.
Do you want me to answer the question? Because I finally have something I know what I'm talking about.
I'll let you answer the question, then we gotta get back to the agenda item. Go
Yeah,
ahead.
since it was brought up,
Thank you.
it's not true that just because you're sued in your individual capacity that the county won't represent you or indemnify you. As a matter of fact, our county has a specific ordinance which, upon finding that you were within the course and scope, that the county will not only represent you but indemnify you for any punitive damages. Again, it folds back to the course and scope.
Thank you. Really, I do. So I'd like to bring Mr. Nelson and Mr. Flaherty up. Gentlemen, would you each individually identify yourselves? And I might ask a question that one of you can answer, and then I don't care who answers the question if one of you knows the answer. So, Mr. Nelson, go ahead.
Shane Nelson from the Office of Hawaiian Affairs.
Okay, Mr. Flaherty?
I'm Charles Flaherty.
Thank you. First question, in this letter, number 4, that was read into the record, the grantor or grantee further agree that the grantee's acceptance of this grant of public access easements is without prejudice, which means, well, I'll let an attorney explain that, to any existing rights to the ownership or use of the historical Alaloa alignment within the property. Does that satisfy OHA?
Well, so according to the testimony, the entire testimony is based around the use and practice of the Alaloa and the right to participate. And that's the obligation of all government agencies.
Okay, so this would take care of, my question is, does OHA accept this clause as allowing the ongoing in perpetuity use of the Alaloa through this property?
So with all due respect, Councilwoman, I'm not going to say yes or no to that question. And the reason for that is because we're also representing a larger part of the Native Hawaiian community.
All right. The reason I wanted to ask...
Mrs. Ford.
Yes, sir,
Um,
Mr. Flaherty.
My reading of that is that, that to me that's not satisfactory because you have the subdivision plat map, okay? The subdivision plat map shows where the lots are. The lots where someone buys it, they have their lot. Well, the Alaloa Trail is not on that map. So when someone comes from the mainland or from this community or whoever buys it, they're buying it without a right-of-way for the Alaloa Trail. So if someone goes and tries to use the guard path, the golf path that's been constructed, the private golf path, they're going to be kicked off because it's not on the subdivision plat map. So I don't think that that condition, while it sounds good without prejudice, the fact that the subdivision plat map is not contained in a legal protection for the Alaloa Trail kind of makes it.
Can I interrupt at this? Okay, so you're giving your opinion.
Yes, this is my personal opinion, and I am not an attorney.
Yeah, I was going to ask you.
I am not an attorney.
So that's my concern, because I see our attorney back there shaking his head, so I'd like for him to come up and respond, because I don't know what.
Excuse me, I have the floor, I'm not calling you up.
Yeah, but I'm having expert testimony, and I
Okay,
don't
you
have.
let me know when I have the floor again, then since you've taken the floor away from me.
Well, because I'm trying to get clarification on his.
Well, then
being
do it on
ex-
your own time.
But you're calling up expert witnesses.
I have a guy from OHA, he represents the state government.
Right, so am
And I
I
have an
having?
opinion, and we've got all these people
Right.
who
Can we
testify.
take a short recess?
Can we show some respect to the
Okay,
chair?
so I'm gonna
How
take a
much
short.
respect to
Okay,
me,
wait.
I have the floor.
Excuse me, I'm just saying that, because if not, we can call up all the testifiers. And so I just want to be clear, so can I take a recess? I need to talk to the court. Thanks. 5 minutes.
And if they're charged with protecting rights, inherently that's weak language.
I've been here 7 years, here's one.
Yeah, that can't even be. If you can a state actually waive rights that are contrary to state statutes, if it happened later, you know what I mean? Yeah, can a state administrator kind of like just usurp all the intentions of a constitution and state? I'll tell you what, they don't get caught up in the public. They actually get crazy stuff.
Go for it, go for it. Everybody was new. They're already
Almost like I have nothing to do with the ownership of the property or its future. And someone asked me for a quick on it. And I actually said something sure there's an obligation if you're submitting the plans to identify all of those
Okay, I'd like to call this meeting back to order. Okay, getting clarification, and because I'm the chair, the point of order, I'm going to rely a lot on the committee members. And, Council Member Ford, I'd just like to say I apologize if I had taken some of your time or try to make some clarification or point, but I just want to stay on the point and making sure that we don't give false impressions to people on who we call up as testifiers and their qualifications to make these statements, and being real clear of what their qualifications are when they make the statements. So I'm going to rely on committee members. If you see that, please call my attention to the point of order. Okay, so I rely on that. I apologize if you can continue.
Thank you. I'll call my testifiers back, and while they're coming up, I'd like to explain one more time. Mr. Nelson represents OHA. Mr. Flaherty was one of 4 plaintiffs in the Kelly case, and that was documented in parts of his testimony. He's very, very, very aware because that case was specifically over the Honolulu. He has some expertise, even if he's not an attorney. So I'd like to continue now. Thank you very much. Gentlemen, the document that's been referred to is 1936, 1938, that apparently extinguished the rights to the Honolulu. Would either one of you like to comment on it? Your mic is off.
I apologize, Charles Flaherty. I've seen the 1936 answer and claim by the Territory of Hawaii related to the main government road and the Mahukona Kauai Beach Trail, Amalua Trail, where the state asserted its claim for those public right-of-ways. I also have seen the stipulation, the 1938 stipulation, whereby the state withdrew its claim to the Mahukona Kauai Beach Trail, Amalua Trail, and accepted an enlarged easement for the main government road. That being said, I went in, and again, I'm not an attorney, but went and looked at the revised laws of Hawaii for the Territory of Hawaii in 1935, which were in place at that time. And there's a section 5041 that excludes from certification of title public highways which do not have their specific boundaries described. I didn't see in the 1938 stipulation, I did see where the main government road was specifically described by meets and bounds in a survey. There's only a general description of the trail. So while I'm not an attorney, to me, it seems to me that perhaps the law that existed at that time, even though the state withdrew its claim, that it was still excluded from the certification of title, and so there is some question as to whether or not the state still owns that right away or not.
Thank you very much. Mr. Nelson, do you have anything to add to that?
No, I don't. I think that's pretty much summing up everything.
All right, thank you. Gentlemen, I don't have any more questions for you, but I would like to make more than a couple of statements, depending on my time. That covered the 1936, 1938 issues. I still do not believe that the planning director who created this subdivision and failed to specify the location of the Alaloa and protect it did his or her job adequately. That's my opinion. I'm not an attorney. This easement has the appearance, or may presume to, extinguish the Alaloa. In my opinion, again, I am not an attorney, but I'm very suspicious of what is here in condition 4. And again, the U.S. government, Department of Interior, claims that trail is there, and it's supposed to be part of their U.S. trail system. And so I'm very, very hesitant to do this. But I have other questions that I hope that I will be allowed to ask other people. Thank you, gentlemen, for coming.
Thank you.
Councilmember Kern?
Thank you, Madam Chair. Well, Mr. Could I have the Mr. Belmonte come forward, and one of the gentlemen from the Department of Interior? Okay, this is a I think the trail is extremely important, and nothing I say takes away any of that. I just want to do this, try to get to the bottom of this in the most factual basis we possibly can, what we can and what we cannot do, whether it's apples or it's oranges. Right now, we're in the Finance Committee, we're not in the Planning Committee, which is, it's different. We're kind of past that land use state. We're trying to basically dot the I's and cross the T's on what was done in the land use side of things. So, that being said, to both, either one of you, the trail was relinquished, the state relinquished it in 1937, 38, correct?
Can you identify yourself for the record? And then proceed.
My name is Kohala Kai National Storage Trail. According to the research that we did, the state did relinquish the trail. However, the county really never did agree to that. For some reason, our research shows that there was no concurrence on the part of the county, although previous documentation will show that the county was not in favor of it. But then again, I think that would be accurate information that we have.
Thank you. Mr. Rohante, in a situation like that, would the county have to agree with it, or would the state? Because the state usually preempts us anyways, that's what they want to do.
No, this is the territory of Hawaii at that time.
Thank you very much, the territory at that.
You know, I think we're in a dangerous area here. I think the discussion is leading to, from what's being, what I'm hearing, is whether or not it was appropriate or inappropriate for the state to relinquish the claim to Alaloa, and I think that's a dangerous area that we're approaching right now.
And that's fine. That's not even. That's actually. I kind of got another question with that. From what we've researched, they did. It's been relinquished. Done.
And whether or not that was an appropriate action at the time,
that's not for us to say right now.
Exactly.
Okay. So I do like looking at the communication. I do like that the coastal easement was made 20 feet. I think that's great. I also think that the part about the prejudice in section 4. Mr. Belmonte, would you like to comment on that?
Following the committee meeting we had in Kona 2 weeks ago, a lot of concerns were raised by both the public testifiers as well as from members from this committee regarding the relationship between the Alaloa and the public access easement that the developer was providing to the county through this grant of public access easement. So following that meeting, upon the conclusion of that meeting, the planning department took it upon themselves to communicate with the developer to ensure that any ambiguities or representations or items that were in the grant of easement that specifically related satisfaction of the Alaloa or the Kohala Kai were specifically addressed. So we, the county planning department, sent a communication to the developer's representative requesting that those specific items be amended or revised in the grant of easement. And that was the basis for this December 16th letter. There was dialogue and communication back and forth between the developer and the planning department. And it was agreed that any representations to this grant of easement, specifically satisfying the public requirement or the public trust requirement or whatever the requirement may be as it related to the existence of the Alaloa and the Kohala Kai were not made a part or a parcel of this agreement. So that was the basis and the genesis for this language, specifically item number 4, that the acceptance of this grant public access is without prejudice to any existing rights to the ownership and use of the Alaloa alignment within the property. And that's all we can really ask the developer to do, is to allow the community who have been using or are making claims that they've been using this trail to continue that into perpetuity or until such time as a determination is made, whether it be by Kohala Kai, the feds, the State Department of the LNR, or whoever who wants to go forward and wants to make a determination that yes, this is the Alaloa, or yes, this is the Kohala Kai, and therefore we are going to proceed with that, which, in other instances that has been the case. There has been recognition of either the Alaloa or the Kohala Kai in other areas, more specifically in South Kohala area. And that's all we're trying to effectuate, was to ensure that that prohibition was not in this agreement.
Correct. So what that essentially allows us to do is to talk about this easement along the coast, and it puts the Alaloa Trail in its own area that can still be used, can still be in conversation. The county is by no way saying that we're saying this is the trail, that we're letting it go, or basically there's no effect to it. We're just talking about this easement.
That's correct.
Which is very, very helpful. So the only other thing that we could possibly do for the county is say, make the easement on the Alaloa Trail, but then you don't have that coastline access. Which I don't think would behoove the people. I mean, there's an easement going along that area, right? Which I believe the blue line, the easement that goes along the trail, is most beneficial for the people to access the coast. The only way to bring the other trail into play would be to move that easement, which wouldn't have the same benefit that the people want in that area. So it's kind of a catch-22. So my personally, I think it behooves the people best to have that easement along the coast, keeping it where it is, and separate out this conversation about the trail, and that way that conversation can have a dialogue on another level, and it's not being done here. That's the way I see it. We have to separate those two things out, otherwise this becomes a very convoluted conversation. We're going to keep going around because we don't have that authority as a council to get into the Alaloa Trail as the way that we probably would like to. It's just not a nice conversation. Might need to go on with the interior, with the state, etc., community, the developer, to talk about that. But by no means us accepting this easement, we're not saying that trail doesn't affect that trail. It's separate. And that's my point, is that we need to separate this out so we can actually make a decision and either accept or not accept this easement, and that other conversation can continue. So I feel good about it with this language now, and I think that's a positive step in the right direction.
Councilmember Edelman?
Thank you, Madam Chair. I have some procedural and also legal questions that I want to ask the council. One of the things that I'm very curious on is, and this has been discussed before, I'm just going to read this whereas. To allow the development of 7-lot subdivision, which require the applicant to submit a shoreline public access plan for review and approval by the planning director. Now, according to Resolution 140-13, now therefore be it resolved that the County of Hawaii accepts a grant of easement. Now what happens if this resolution doesn't pass and is voted down? Does it mean that the developer doesn't have to submit a shoreline public access by turning this down?
Councilmember Iligan, may I respond to that question? I think, again, we're going to wind back, as Director Kanuha has stated, that there are two applications here. The first one was for a 7-lot subdivision, and that was back in 2001, 2000. The second one was for an additional subdivision within one of the original 7 lot parcels, and that was in 2005. As it relates to the original application for the 7 lot subdivision, it's my understanding through a review of the record that that subdivision has already been approved. So that 7 lot subdivision has already been approved. So actually the specific matter in front of us relates to the 2005 application, which was the additional subdividing of one of the original 7 parcels. And I believe it's for this additional 5 lot subdivision. The public access easement was somewhat vaguely construed because in the initial application for the 7 lot subdivision, there was a SMA minor application or permit that was required. And that SMA minor permit required the public access easement be dedicated to the county. Unfortunately, in the 2005 application for the 5 lot subdivision, there was just a minor reference to that public access easement. So what the planning department is doing is they're using the language from the original 2001 SMA minor, and they're using that to formulate the intent of the much more vague language which was in the 2005 second subdivision application. And that's where the requirement for this public access easement is coming from. So when Director Kanuha was explaining that if this body were to reject or not accept this grant of easement, then in essence, the 6 lots that were part of the original 7 lot subdivision, we would not obtain any public access through that section because that's already done. The only area where the public access is specifically required and still open for consideration relates to the 5 lots of the second application. So, to answer your question, and I'm taking the roundabout way, but to answer your question, I think if this body were to, it's not a committee, but if this matter goes up with an unfavorable recommendation to council and ultimately at council it gets denied, then the matter goes back to the planning director and a determination will be made based on the totality of the circumstances and everything in front of the director at the time as to whether or not the applicant substantially complied with or satisfied the requirements of the second subdivision approval.
So, the first go around, that it's actually 5 subdivision lot. The current one is the only. Actually, I think what I'm gonna do is look onto the map and see where those lots are located, and then find out exactly if it's on that those trail areas. Because right now I don't have that in front of me, and I don't want to take.
To provide any clarity, if you look at the map that was attached to the communication that was provided to us, the December 16th letter from the applicant, you can see where the lateral public access from both the northernmost portion of the property, which would be to the left of the page, coming all along the bottom lateral section of the property, to the right side of the page, which would be the southernmost boundary of the property. You can see that the proposed public access easement that we're discussing here today incorporates both the 7 lot subdivision as well as the second 5 lot subdivision, and it runs contiguously across each and every one of those parcels.
So, go ahead.
I guess one last thing. So technically, if we do turn this down in council, the developer is only required to fulfill the public access on the 5 lot, which will make it incomplete for the whole trail because the other 7 really, they've met those requirements. Is that a guesstimate?
To put it, I guess, clearer, kind of as best as I can. Hopefully I can accomplish that is as it relates to the original 7-lot subdivision. That's kind of in the past. There's not much we can do about it. We're fortunate enough that the second application is still open. The second 5-lot subdivision application is still open. And we're using that as the basis to require that the developer satisfies the public access requirement so that the public access can run continuously across the entire original parcel of land.
Well, thank you so much.
I'm gonna call a 10-minute recess. Thank you. And we have Councilmember Wood.
Thank you. There are requirements in the various approvals, and there's implementation of those requirements. And many of these requirements were back a number of years, whether it's pedestrian easements, improved for public use, or the more recent one, it says the lateral pedestrian public trail shall have a minimum 6-foot wide walking area with a graded earthen surface to allow reasonable pedestrian passage. So my concern is that implementation, not the appeal period from when the requirement went in there. And I had hoped, as Councilmember Kern said, no, if we give the 20 feet, that'll take care of it if we widen it. And it's just, the concern is that really the 20 feet, if you have rocks and it's uneven, it still doesn't really provide. If you look at the pictures we were given, an earthen trail for reasonable pedestrian passage, unless we just want to address the agile fishermen. So that's sort of where what are we taking on as liability? There's a corridor, and then there's the path itself. So the path itself really came to light just in this year. And I'd like to call Rick Rimkin and Department Curie come up here and how to deal with this. And while they come up, I just want to make one comment in terms of that section 4 where we say whatever we do doesn't prejudice the the ancient trail, the Aoloa Trail, is that my one concern there is I would think it would have to be on the plan so that the person purchasing the property would have notice. In other words, we would impose that on a third party. But I'm going to set that aside. I just want to ask you, did you go on Friday with my assistant Dave and walk the trail with other members of the community and hear you?
This is our copy of Kohala Kai National Historic Trail. Yes, we did.
And did you feel that it was, as the trail, not the whatever corridor, that the trail that's constructed meets the requirement of being a minimum of 6-foot wide, graded earth surface to allow for reasonable pedestrian passage, in my view, sort of the general public?
In my opinion, you would have to be in pretty good shape, in order to negotiate that trail. It would not be something that children or elderly or those living with some handicaps would be able to safely traverse.
And could you speak up a little, louder?
I think while we were out there, you were asking if...
Oh,
I'm sorry, yes. My name is Rick Demerkin. I'm the archaeologist for Kohala Kai National Historic Trail. Thank you very much. I think your question was whether it was 6 feet wide out there.
Reasonable public passage for the general public use.
I'll just reiterate what Art is saying. For the agile fishermen, it is a good trail for that. For anyone, we typically like to talk from Keiki to Kupuna, and it eliminates both extremes on that. Keiki, it's a little bit hazardous because of the the close nature of the cliffs on the side. For Kupuna, the footing is just not, it's just not there.
And my well-intentioned suggestion of going to the 20 feet, did that somehow cure this problem?
I believe, and again, I'm not completely sure what that means. My understanding is that that allows the movement of that trail within that 20-foot segment. What makes me a little bit nervous is, in some places, it could, you know, go past that 30 feet. We're talking about in perpetuity. We're not talking about, you know, 10 years, 20, 50. We're talking about forever. And I just am concerned that is not enough time for, or enough room for that in the long term.
And just so the other council members, that's my concern, is looking at the pictures and the 2 feet is, and some of them, it's how to address that, and do we accept something where everyone that was present in that walk felt that it was the 20 feet, even 30 feet didn't really address it. So that's my big problem, accepting something where we as a county look at it. I'm not getting into what legal issues were in 1930s, 40s, whatever. It's just were the requirements implemented? My understanding from what Larry Brown said and others is that really the trail was constructed before the access plan was submitted to the planning department. And so then when they went out there as a violation site check, the planning director then said, okay, I'm going to accept this. But I don't see it as this. If what was provided here was the 6-foot walking area, where the actual walk area was graded earth surface to allow for reasonable pedestrian passage, I would say, okay, and we do the non-prejudice, and they put it on the map, so it shows where that trail is. I think that's the key. Otherwise, those people who buy the lots, as a lawyer, I would say you can put your house there. You know, you don't have notice. You'd have to bring the lawsuit with each one or something. And I also think, did you talk to the planning department or the director then back in January that where you thought it should be and where under the should be on the Alawoa? I mean, was this made clear to the planning department? You can just say yes or no. Did you make it clear?
Yes.
Okay. And I want to make one just concern that I have about where we say, and it can be widened or moved up if it's, you know, the trail disappears. It's not, I really feel that we need to figure this out here and now, because other properties where that's been the case, once the trail erodes, and some of it's already been washed away, as the example happened, nothing happens. Aren't there some places where it's now been blocked because that happened and there's no passage there on the trail?
There are some examples of that in North Kohala at Kohala Ranch. That seems to be the circumstance where we've been working with the county and the state on trying to resolve that, but it's been 4 years in the making so far.
Okay, so my concern is just here where we're cutting it out and then it will be individual owners owning this rather than keeping this whole corridor that could be, how does one address that in the future? So those are my concerns. What liability are we as a county accepting? And where are we deferring our responsibility? And where are we not with requirements, but with the implementation, which happened this year, and is that satisfactory? So I yield to listen to what anybody else has.
Councilmember Onishi? Okay. Councilmember Young? Oh, excuse me, I'm sorry. Councilmember Ford. Before we took a break, I had to then I come.
She hasn't
Oh, you haven't spoken first. Oh, I'm sorry. You know why? Because I had this before I went into break. So I came back from break promising them that they would go over. Since you did go first on the first session, yeah. Councilmember Young, sorry.
And I really find myself in a pretty unique position here because through the 80s and 90s and 2000s, my work was with regards to better land use practices when we face development and how that's going to impact traditional and customary either gathering rights, access rights, or practices, and as well as the public's access to places. So this is really difficult because there's been such a series of wrongdoings, maybe going back to the 1936 or 38. But how do we undo it? I really am kind of at a loss. But I don't want to make any more wrong decisions here. So I guess that's why I was hoping at the last meeting when I spoke about postponement, in hopes that the applicant would work with the community. I realized that we can't make this totally right because there's been things done already that we can't undo, but in hopes that maybe there would be some sort of a compromise or a willingness to come to some consensus with the community so that there wouldn't be a need to be threatening with lawsuits and all of that. So I do see that the number 4 starts in that direction, and that helps us, and it helps us to separate the issues from one of a public access easement that was agreed upon or required, and separate that from the Alaloa. But I'm still worried that even though the Alaloa maybe has some legal problems attached to it with the state giving it up or whatever, to me that doesn't mean it doesn't exist anymore. It still exists. People still use it, and Native Hawaiians feel, and the National Park Service and all of us feel that it's a part of a historical trail system. So I'm really, really not sure what we're supposed to do here, besides ask the applicant to give a little bit more, possibly. And that, in some of the recommendations from the one letter that came from the community group, and I'm not sure how this would work, but the concern is that the proposed golf cart would be paved on top of the Alaloa, and then that would become a private pathway for residents in the subdivision and no longer a public path. And I don't see anything in here that would guarantee public access. I've heard there may already be some restrictions to that access on the landowner. And so we haven't heard from the landowner yet. So I would like to hear more on how we can retain public access along the Alaloa corridor, or determine where it is, and whether we can still vote on accepting a grant of easement in order to assure there's public access to the shoreline. I don't want to do something that all of a sudden keeps the public away totally, by not accepting the grant of easement. So, I still want to postpone it further because I think that the developer or the applicant kind of failed to really come to an agreement with the community. There were some attempts, but from the people that I've heard from in the community, there wasn't a showing at, a real good showing of communication yet, or exchange of communication. Maybe the public hasn't had time to see this change to the grant of easement document, but I'm not sure if that totally will alleviate some of the concerns. So that's just my statement at this point. I'm still unsure what to do as far as voting on a grant of easement at this time.
No, Drew, council member, you spoke before? No, you didn't? Okay. Council member Kanina?
Thank you, Madam Chair. I understand what everybody is talking about with this. We want to make sure that the public knows exactly what we're doing. We need to make it completely clear that if we do accept this grant of easement, what does it do? If we don't, what doesn't it do? So we need to make this all clear to show the public and to make sure the public understands exactly what's going on. There's a big confusion with a lot of people that not really everybody is completely understanding the ramifications or the unintended consequences. So if we do go forward with this, let's keep it clear of exactly what happens. Saying that, I actually would like to hear from the applicant. You've heard all the comments and concerns. I'd like to hear any response.
Can I ask you to step back? Thank you. state your name for the record and then proceed. After this.
Please, just, you've heard everybody comment about their concerns. Please respond, if you can. Your microphone.
Good afternoon, I'm Stephen Dem from Portsmouth, and to my right is Mr. Charles Anderson, a representative from Kohala Kai LLC. Thank you again for taking up this matter. We know it's contentious. We know it was going to be contentious when it came in, and we tried to address to the extent we can, the concerns of the community. Effectively, what you have is the very tail end of an approved project. It's a grant of public access easement to the county. Once you, assuming you do accept the grant of public access easement, the things that you may have concerns with in terms of wanting the trail to be better or wider, the county has maintenance ability, you can go in there. The Kohala Kai, and I don't think you've heard anybody say in this proceeding that Kohala Kai didn't follow any of the rules. I think quite to the contrary. I think you heard Kohala Kai followed all the rules. They made all the contacts with the North Kohala Community Access Group that they did for the last 2 years plus. And they came up with the public access trail that the planning director inspected, had them revise, and have already approved the grant of public access easement as it was originally proposed. We've made changes since the last time we met a couple weeks ago in response to some of the issues raised by Ms. Willie and other members of the council, especially on the Alaloa issue. I think that the paragraph 4 that we inserted in there makes it clear that if there are any rights at all to the use or ownership of the Alaloa Trail, that what you do here in this resolution does not affect that at all. And obviously, you know that our position is that there is no Alaloa legally or physically left on the property. And we've submitted those documents to you. One of the questions was, did the county didn't stipulate to that. In fact, the county did stipulate in a form of default. They were served with the title action way back in the 30s. They didn't answer, and a default was entered against them. You have that in your record in Exhibits 4 and 5. The suggestions that you could go back in to redo SMA permit number 84 or 0610 that have been issued for the project at this point in time, I think are misplaced. Just like that court action, and the lawyers here on this panel will tell you, just like the court action, the administrative final decision that the planning director made in this case are appealable, but only 30 days after the date of the issuance of those orders. So both for the Alaloa land court issue and for the SMA permits in this case, it is too late. The time for appeal has passed. We are left now with satisfying the condition, and we agree with Mr. Brilhanti's interpretation that the 2 permits don't clearly require that we be here before you today, but Kohala Kai wanted to be here. They wanted to do the trail, they wanted to do the right thing, and we're just asking for the council's support to accept this grant of public access easement in the location that it has been built and approved by the planning director. They spent significant funds to build the trail to the requirements of the planning department, and I think that the county council may be equitably stopped from accepting something that you build according to county standards. So we believe that, when we understand the issues that the Alaloa Trail and all it brings with it, we get that. But that's not what's at issue before you today. We hope that the addition of paragraph 4 into the grant of public access easements will address that issue for the council in terms of not waiving anybody else's rights. And so we would ask for your support to either vote it up or vote it down.
Thank you. Yeah, I'm kind of, up in the air about this. There is a concern about the Alaloa, and you know, I'm always going to be an advocate for our trails and access, but this is kind of a difficult situation because there's a lot of things that happened in the past that we're trying to correct now, and it almost doesn't seem legal for us to correct them now. Even, I don't know, it's just really confusing at this point, but it's kind of disappointing that a lot of things happened in the past. I'll just say that. But how do we make this better currently? And how do we make this turn this around into a good thing? Is what I'm also struggling with. By accepting this grant of easement, the county is accepting the liability, I'm assuming, and you know, with the testimony and people saying that certain places aren't that, you know, accessible for our kupuna, for our keiki. If something should happen on this trail and we take that responsibility, you know, what that's pretty difficult, you know, to think about. But I'm gonna say, you know, you follow through with what the county, you know, said that you should do, and model for that. I'm not gonna say that you maybe met with everybody you should have met with, but I'll just yield at this time. But that's my concerns. I have kind of the similar concerns with Margaret Willie was saying earlier about the liability issue, but I don't know what can be done right at this point. I'll just yield at that time.
Thank you. Councilmember Ford?
Thank you. Would you gentlemen step back, please? Mr. Belmonte, would you come forward? Mr. Belmonte, do you have a copy of this condition 4 that they've added to the paper?
William Bronte, yes, Ms. Ford, I do have a copy of condition.
Please open it to condition 4.
Communication 34327.
So page 7. So, Mr. Belmonte, let's assume for a second that the state really did extinguish, rightfully or wrongfully, they've extinguished the rights to the Alaloa. Okay, they've extinguished them. So if that's the case, number 4 says, without prejudice to any existing rights. If there are no state rights because they've extinguished them, then number 4 means nothing. Is that correct? If there are no state rights to that trail, then them writing in without prejudice to any existing rights means absolutely nothing.
Not essentially, because...
Really? If there are no rights by the state, then there's no existing rights, right?
Yeah, but there would have to be a lawsuit to make the party would have to make a lawsuit to establish the existence of a right and go back and say that that action in 1938 was wrong.
Okay,
so
well,
I think we're splitting hairs here.
No, I'm not splitting hairs. If there's no rights, they've written in something that says, if you have rights, fine, we'll accept them. If you have no rights, then we don't accept it.
Again, I think that's going to be have to be a separate determination that's made.
Okay, and we can go back to the late 1930s and have a court adjudicate on that issue? Not us, the county. I'm just saying, the people. They can choose to do that.
The correct look I gave you is...
Yes. They choose to talk to their own attorney. Okay, that's fine. So let me explain how I think we need to fix this. I don't expect the developer, the applicant, to accept this. This whole thing would have gone away if the applicant had, whether there's existing state rights or not, if they had defined the metes and bounds on the Alaloa across all of these properties and deeded that over to the county, not to the state. Let's assume the state did extinguish the rights. Just do the metes and bounds on the Alaloa, give it to the county, we're over with it. The federal government will be happy, we'll be happy, the people will be happy, everybody's happy. I don't expect that to happen, but that's what should have happened. Secondly, I'm very concerned about the shoreline easement. It's not safe. It's not wide enough for forever. It's just not. Some of it's underwater right now, and it's dangerous. I'm not saying vote this down for that reason. I think that that shoreline easement is inadequate, and I don't think that the planning department should have accepted it under the conditions that are written into this document. it needs to be much wider, we might have to improve it, we've got the liability, which the county accepts liability all the time on stuff like this. But if you're looking for Keiki to Kapuna, it isn't there. And why are we trying to accept an easement that's inadequate, substandard, and even dangerous? I'm suggesting that the applicant give the Alaloa to the county, do the meets and bounds by whatever method, give it to the county, get that one taken care of so we stop having a big uproar about it. And the planning department needs to go back and say, this 20 feet, which by the way was in the application, I think it was 20 feet in the application, so they're not getting this anymore. It's not, wasn't 10 feet in the application, I'm not sure about that.
It's 10. No.
It's 10 in the application, okay, 20 is not sufficient. It needs to be much, much wider, and it should have been improved. We don't accept streets in these conditions, and this is a foot trail, and it's not even safe. We're going to have people dropping off into the ocean and getting killed. So I'm not saying to not vote for it this time. I agree with Ms. Eop. This needs to be postponed, and I'm going to ask the applicant to come up. I want to get him on record as refusing to do what I'm asking. Sir, would you like to come up?
I asked, Mr. Brownhampton wanted to respond to.
Are you in my
No,
testimony
he's
again?
asking, I'm asking you, Councilmember Ford. Mr. Brohanti is asking to respond. So I'm
To
asking.
No, thank you. Would the applicant like to come up and respond to my question about deeding the Alaloa to the county?
I believe Kohala Kai LLC's position is that they would refuse to deed the Alaloa alignment if there is one within the property to the county of Hawaii.
Thank you for that response. It's honest, and I appreciate your honesty. So, what should have been done in the beginning hasn't been done, and we've got a big mess on hand. I support postponement, but I'm going to step back and move it on. Thank you.
Since Councilmember Yoshimoto didn't speak yet, but Councilmember Kern was next. Okay, Councilmember Yoshimoto.
Okay, council members have been listening very carefully, trying to process the information from last time as well as this time. And that's why I haven't spoken up, because I kind of want to get a good feel as far as what are the issues before us. Mr. Brohan, you can stay up there. No. Okay. So Mr. Brohan, you just heard the comments of Ms. Ford, and you seemed like you had an issue that you wanted to raise with us. Go ahead.
What I want to do is just be clear on the record that I appreciate Ms. Ford's concerns regarding the safety issue, and I don't think anybody here in this room would want anybody to fall into the ocean, no matter what. So just to make sure the record is clear as it relates to the safety issue, there is a provision in the grant of public access easement, specifically on page 5, that states, if portions of the public access easements erode away, destroying the public access easement or making said easement hazardous, the public access easement shall be relocated to a safe location immediately adjacent to the destroyed portion of the public access easement. So there is a provision which generally is incorporated in these grant of easement documents when it comes to public access, because we understand that the shoreline, it evolves, it moves. High waves or high surfs will erode portions of the shoreline. So there's always this provision that if portions of this trail become unsafe, then we will take corrective measures.
Okay, thank you. And don't go away. Okay, Mr. Brown, I need to reiterate some things because as we're talking about this, we're getting information that's kind of conflicting or consistent. It kind of depends what topic you're on. So as far as the Alaloa, you stated earlier, and you correct me if I'm wrong, you stated earlier that the state had relinquished its rights to the Alaloa back in 36 or 38. That's correct?
I don't think I ever specifically said that, but there is information on the record that there was an action in 1936 as well as a subsequent action in 1938 where the state did relinquish rights to what was then described as the Alaloa in exchange for a portion of the Kohala Highway.
Okay, and the documents that we have been provided indicates that there was a default, I guess, taken against the county for failure to act. Your research also showed that?
There was some evidence of that, yes.
Okay, and, you know, we all know that just because, I mean, that was done in the past, doesn't preclude any kind of subsequent suit, of course. We all know that anyone can file a suit for pretty much anything. I think that's your point, right, as far as...
Yeah, you know, just because that transaction took place, we're not making any representations as to whether or not the, you know, the sustainability of that transaction, you know, is it challengeable? Possibly. Could we prevail? Could a member of the public prevail? Yes, but, you know, that's a different venue and for a different time. You know, that's not what we're discussing or should be considering at this point in time here today.
Okay, so to be really concise, what we're here for today is whether to approve the grant of easement, correct?
In satisfaction of the SMA permit that the planning department required the applicant to obtain and to comply with in their two subsequent or two previous subdivision applications.
Right, so like as someone characterized, you know, we're at the tail end of the process, right?
That's correct.
So, you know, do we have any authority to change what was already done by the planning director or department?
As it relates to the conditions of the two previous SMA, the minor and the major,
right.
I would have to opine that we wouldn't be able to amend the conditions at this point in time.
You know, and I would concur with that. I mean, that's just my understanding of the process. So, you know, therein lies the problem, you know, council members, because you probably heard this before. I mean, we only can do what we can, and you know, if it's beyond our authority, then you know we're left with a situation where you know if we accept this resolution, you know, there'll be an easement for public access. If we don't, we heard from Mr. Brahante that this goes back to the planning department, and you correct me if I'm wrong here, then the planning department, the director, will determine whether they substantially complied, you know, with their obligations. Mr. Brahante?
That's correct.
And so that's, you know, it feels like, well, we're kind of caught. But, you know, my emphasis, council members, is we only can do what we can, whatever authority we have. And so, Mr. Brahante, you wanted to add anything else? Oh, Mr.
I think Mr. Kanoa would like to chime in. Director Kanoa.
Yeah. Thank you, Bill, and members of the council. I just wanted to add a couple things, right? Besides the state, or the territory at that time, releasing claims to the, what was that, the old Kohala Trail, yeah. Subsequently, in conjunction with these permit applications, the applicant conducted their own archaeological research throughout the whole property. And the state Office of Preservation was also asked to comment on those findings. And the State Historic Preservation Division basically said, in their opinion, there's no evidence of the trail. So, given that in 1933, for reasons of exchanging for a better pathway to create Quantiputi Highway, we're assuming, we fast forward to within the last 10 years, the State Historic Preservation Department is also asserting that there's no evidence of that trail along this alignment. Okay, that's one clarification there. The second one is that if this grant of easement is approved with the language that's been revised here, two things. Okay, it gets recorded. Okay, so it gets recorded as a covenant against this property, and that condition 4 on page 7. Okay, about the without prejudice. It basically says that with that language in there and this being recorded against the property, I would need to take that into consideration prior to granting this project its final subdivision approval. Okay, so in terms of you know, completely shutting it off, that's what I would have to do. I'm just letting you know that it's, that end of the responsibility is part of something that will flow to the final subdivision approval, but it can only happen with your action, right? Because if the grant of easement is accepted, then it gets recorded. That condition there, which basically says anybody can still go back and do whatever it takes to challenge that, that gets put in place. So I guess what I'm saying is that I would probably require some recognition of that on the final map itself to begin with. Now, this section of the project now is right in the middle. You realize it's right in the middle. So if there are efforts, to reassert some claim on that section of the trail, it would only be through that portion of the property that's through the middle.
Okay, so Director Kano, your opinion is you're referring to paragraph 4 on page 7 of the
Correct, right.
And as you're saying that that newly added provision provides a safeguard that if there were to be a subsequent challenge.
Well, what I'm saying is, to me, that language directs me to consider that when I grant the subdivision approval. Notwithstanding whatever I grant, all of this is going to be recorded against the property. So I'm sure there needs to be, or there would be, I would have to make sure that that is in there. In other words, how the lots are configured, things of that nature, I'd have to take into consideration. Okay. To accommodate this potential in the future, I suppose.
Thank you.
Councilmember Kern?
Thank you, Madam Chair. Well, I think we could either call for the question or postpone here in a minute because we're going to keep going around to gather more information. But before we do that, I want to move to amend resolution 140-13 by replacing Exhibit 1 with the grant of public access easement as provided in communication number 343.27.
Second.
Wait, 343.
That's the document, December 16th, that we've been working off of that has item number 4 in it, that has all the changes that have been made. That way we're actually dealing with that document with the proper amendments. It's basically amendments. We've been discussing it because it's been read in, but we haven't actually
Made a motion, okay.
Yeah. And so that's the proper motion to be made.
Okay, so you're making a motion to amend with the Councils of Communication 3.27.
Yeah, I'm making a motion to amend resolution 140-13 by replacing Exhibit 1 with the grant of the grant of public access easement as provided in communication number 343.27. That, it basically just brings it in so the document that we have been discussing during this time is what we'd be voting on or postponing.
Okay, so
Second. Did you get a second? Oh, you did it, okay.
Okay, so it's been moved by Councilmember Kern and seconded by Councilmember Onishi. So, any discussion on that amendment? Councilmember Woody?
I have a question for Director Newman. When you read the requirement that the pedestrian path shall have a minimum of a 6-foot wide walking area with graded earthen surface to allow reasonable pedestrian passage, would you accept something where the pathway as opposed to the corridor is 2 feet wide?
Where the pathway as opposed to the corridor?
Yeah, this is the minimum. It talks about, in other words, we're talking about 20 feet corridor, okay?
Yeah.
Then you have the area that you walk in, okay? And, and where the requirement is a minimum of a 6-foot wide walking area is in their public access plan
Okay.
with a graded earthen surface to allow reasonable pedestrian passage. I mean, we keep talking about that catch-all, you can move it,
Correct.
you know, you can move it. We're saying it's already hazardous and reasonable. If we could just adjust that right now, and not wait till, I just worry when it gets sold to other people. It's not that easy as was brought up by the others. So I just think sometimes there's a confusion what Councilmember Kohala said. Let's be clear. There's a corridor, you know, you put it in a corridor, you have to do, and then you have your area you walk on, and the pedestrian plan talks about the walking area.
Walking area is the walking area in the approved plan is, I don't have it in front of me.
Is 6 foot wide walking area with a graded earthen surface to allow reasonable pedestrian passage. So I just want to know, how do you, because everybody said, well, the requirements, you know, you prove this, you prove that, we can't do it, but we can ensure that the implementation is appropriate. And if you see right now what people have said is there's already areas that have gotten washed away, okay? And I just don't want to wait till those lots are sold. Let's, if we got the right to move it to where it's no longer hazardous, have you addressed that right now? So you understand, I just, the corridor and the pathway, I think sometimes get confused. We're not asking for 20 feet to become.
Correct. It's where that corridor goes through.
Clearly, all the testimony and looking at the pictures, we're talking, you know.
Excuse me, point of order. We're on the subject of the amendment on communication 343.27. But this really is.
Oh, this is quoted out of.
I know that.
Okay, their public access plan, which this approves. So I'm just trying to look at. I'm looking at how one implements words, okay? Because people said that, you know, that requirement, and that's what he's been talking about. You can talk about that in a minute.
You know, I don't have the plan in front of me, but can you enlighten me as to who makes the determination as to when it becomes unsafe or below the minimum?
That's why I'm asking you. I've had Dave Hurt walk and the different people there. And it's all partly eroded and there's sort of precipice in places. And it's down to, you know, 1 foot, you know, 2 feet. And I realize, I'm just looking at then the county takes it on and then suddenly we're in executive session because somebody slipped off here. And I'm going, Margaret, what did you do? You know, what did you approve? So I do feel we have in that where it talks about you can move it where it's hazardous, where it's eroded. What everyone's saying, and if you want to talk to Rick or Art, you know, then, it's already that way in places. So I'm not getting into the legal 1930s, and I'm not getting into even the Analoa. I just want to say this requirement, to me, provides a level of safety and can separate out requirements from implementation.
Councilmember Willie, in communication 343.27, which is the requirement that you're referring to? Okay. Because we're discussing 343.27.
They submitted the plan. This is their plan.
It's not in.
Yeah. So right now we're discussing just the 343.27. Okay. So we can come back to you when we go back to the.
I understand what she's trying to approach.
So I want to stick with the 343.27. So any.
Madam Chair, we've been talking about this the entire time. It's not a new subject. It's just bringing it together so we don't have to just amending it. But
so you guys want to talk about everything together? It's fine.
That's what we've been doing.
This is on the motion.
Yeah, that's what we've been doing. There's nothing new. Just trying to get housekeeping order.
Okay, because I just had a point of order. Councilmember Ford.
Thank you. On page 5, under the highlighted Malcolm Mackay and lateral pedestrian public access, it reads, public pedestrian access easement on the existing trail for Malcolm Mackay pedestrian access being 10 feet wide. That means the uphill, downhill is 10 feet wide, not 20. And on the lateral pedestrian public access being 20 feet wide, measured from the Mackay edge of the reconstructed Fisherman's Trail, doesn't sound reconstructed to me, containing, anyway, so, but then when you look on the maps that are attached, the exhibits, you will notice that they all say proposed public pedestrian access 10 feet wide on existing trail. Is that on, I can't tell if that's on center, or they're negating what they just said on the lateral. That's supposed to be 20 feet wide. But certainly the Malcolm Mackay is 10 feet wide, both in the written page, written information on page 5 and on the exhibits, the maps that are exhibit 1 and exhibit 2. So there's some discrepancies in here that I think need to be addressed before the next meeting, which I hope will be postponed so we can adjust it. That's all I want to comment on in this. We just received this today, and I would really like some time to read this before we vote on it. Do you understand where I'm talking? Page 5, the Malcolm Mackay is 10 feet, the lateral is 20 feet, and the maps, the exhibits 1 and 2 only show 10 feet for the entire Malcolm Mackay and laterals.
Okay, I just want to answer the question.
Well, I think the developer needs, excuse me, I think the developer needs to answer the
So
question.
Councilmember Ford, do you want to call up the developer?
Well, I put, yeah, you can come up and explain this, why there's inconsistencies here.
And state your name for the record again, sorry.
Stephen Lin from Carl Smith, this is Charles Anderson from Kohala Kai LLC up to my right. And the exhibit should state 20 feet wide on the lateral.
It does, I don't see it. Where, if you can point it out to me, it says 10 feet on exhibit 1 and 10 feet on exhibit 2.
You're right.
Here's the 20 feet, and here's the...
Margaret, it doesn't match the exhibits.
Okay, so
Is our counsel giving counsel to the applicant on my time? Go ahead, Mr.
When we
Wayne.
made the amendment for Ms. Willie's suggestion to widen the lateral access to 20 feet, we didn't do the change to the exhibit, but that's a clerical error that we can change at a later date.
Okay.
And we will do that.
Thank you. I'm going to yield on this amendment at this time.
Okay, thank you. Councilmember Kern?
Let's vote on the amendment, and we can get back into discussion. I'll take the floor for that.
Okay, are you calling for the question?
No.
Yeah, call for the question.
Second.
Okay. Because it's just on the amendment that you're calling for the question. Okay, so, all those in favor, say aye.
Aye.
All those opposed? Are you saying no? Okay.
Okay, I'll say no too.
Okay. 7 ayes and 2 noes, so the amendment is, so we're. Oh, call for the question, I'm sorry, now we're gonna go for the amendment, so regarding communication 343.27. Okay, so, yeah, do I need to do a discussion or just call, for because it was called for the question? Okay, so all those in favor say aye.
Aye.
All those opposed? Okay, so we have 9 ayes, so the amendment, resolution 140-13 is amended with the communication 343.27. So any background discussion on the main motion, resolution 140-13?
Madam Chair?
Yes.
This is a significant and substantive change, and we should just hold this over till the next meeting.
Are you, make a motion?
No, you don't need the motion.
Oh, you
This
don't
is a
need-
substantive change that the public
Okay,
needs to
so-
look at.
Because we wanted to make a motion to postpone then, are you saying?
No, I'm
Okay,
saying this
okay.
is a substantive change, and we're supposed to hold it over.
Yeah, this doesn't apply in committee. Those are
That's
the last
okay,
final
we
meeting.
should still do it.
Yeah, because in committees, don't we have to do a postponement or
Fine,
put it in
I move to
recess?
postpone whatever this bill is, hold on, 140 to the next committee meeting.
Do I have a second? Okay, so it's been moved by Councilmember Ford, seconded by Councilmember Willie to postpone this to the next committee meeting. All those in favor say aye.
Aye.
All those opposed?
No.
Okay, so we're gonna do a roll call. Mr. Court?
Is there any discussion before?
Oh, yeah, on the postponement, we can discuss on the postponement. Do we wanna discuss anything on the postponement? Karen, Councilmember
I would just
Young?
like the applicant to please come forward one more time. If you do postpone this, would you be willing to try one more time to meet with the members of the community who claim that you either weren't able to show up or didn't include them in the meeting, just to go over what some of these changes would mean and see if there's a little more, if it relieves some of the concerns, or maybe there's a little bit more you could do to make the trail safer in the minds of people who feel that it's not. If we postpone it, can we please request that you would make a better effort to bring that back to us?
My name is Charlie Anderson. I represent Kohala Kai, and I'd be happy to meet with people from the community. We've done that. I've attended public access meetings for the past 2 years.
Well, I know you
Every
say
month.
that, but then
No,
recently
it's-
I was told that there was a meeting and you didn't.
There was a meeting in North Kohala of the North Kohala Public Access Committee. I attended that meeting the last 2 months, and nobody from South Kohala comes to those meetings. This is a.
I don't want to
this is
argue
a-
the
this-
point, but I just know that there's people out there who feel they haven't had a chance to talk about it, or maybe since you've made some changes here, that it would be good to explain those to the community, who now is very active. I mean, we've had very compelling testimony today and last time. I mean, I don't want to just keep postponing if nothing changes, but I would just really appreciate if there would be an effort.
Council?
I guess the question is, would you be willing to try and meet with the community again?
It's a South Kohala.
Oh, South Kohala Group. Is it specific to South Kohala Group? Because he's saying he met with the Kauai High Group, so you're talking about.
It was the Kauai High group that wanted to meet.
Okay, so. Yeah. So Karen, I'm just asking, are you waiting for an answer or what?
I've talked to Mr. Anderson, and Kohala Kai LLC is willing to meet with the community again. We'd like it to be one meeting, however you want to arrange it, so that we don't have to go to numerous types of meetings, but we'd be willing to do that within the next 30 days. I cannot tell you that anything different is going to come back to you, but I can tell you that we're willing to talk, because we respect their views, and they've been very open and polite to us, so we want to go and do the right thing and try to see if we can reach a consensus. But I just cannot promise you that will make any changes to what you have today.
Well, I think we learned something here today. There's some new information that is more clear, and then there's been some changes that amend this.
Okay. So who can arrange this meeting? If we're talking about a meeting, Karen, I mean, do you have any suggestions?
Well, I know Ms. Willie was out of town this last couple of weeks, and it is her district, and I
So
don't know if she...
are you asking Ms. Willie, I'll let her answer if she's willing to.
Yeah, I'd like it to be that when we postpone to the later January meeting, so okay, that's all I'm asking, so we can meet.
Would that be about 1 month?
Yeah, that's about one month.
So the meeting with the community will be before we come back to our next.
Yeah, it won't be until January, because I will be away.
Yes, Councilmember Ford.
I made the motion to postpone, I believe, but I didn't set a date.
Okay, so on the motion to postpone,
I'd like to amend it
she'd like to amend the motion to postpone.
to January 21st, that is 1 month. That is the next committee meeting. 2 committee meetings from now. So I amend my motion, and I'll restate it for the record. I move to postpone Resolution 140-13 to January 21st committee meeting.
So, I just, for clarification, do I have to, should she withdraw the first motion or just make a motion to amend? Because she's amending, and we're gonna discuss the amendment.
Just need to withdraw it, just for the.
Yeah.
Okay, let me start over. I withdraw my initial postponement.
Okay.
Now, I move to postpone Resolution 140-13 until January 21st in the Finance Committee. And I need a second on that.
Okay, so there's a motion to postpone to January 21st, 2014. And it's been moved by Councilmember Ford and seconded by Councilmember Willie. Any discussion of the postponement? Councilmember
So
Yoshimoto.
let's just check. Are you able to come back on January 21st? So make sure my schedule is. Somebody will report back. Okay, that's the main thing. Thank you.
Okay. Councilmember Kern.
Yeah, I just, think doing a community meeting is obviously a great thing. Whether it changes things or not, we understand that. What I would like to is if there's any other issues there, like Margaret's been bringing up, let's get those, try to get those ironed out in the meantime so we can actually come here with something on the table to say, here's a solution, here's what we got, let's move forward. Instead of just continually, here's a concern I have, but we don't really get always to the resolution. So that's just my request, is let's do our very best to, because I feel, you know, I'm getting more comfortable with all of this, but let's get a resolution so we can move forward and people go about their business.
Any other discussion on the postponement?
I'd like to involve the
Councilmember Willie? Oh, okay. On the postponement, Councilmember Eo?
I think, yeah, the planning department, OHA, some of the national park, some of the stakeholders that have come forward to testify. I think Ms. Willie knows who they are, so I would really hope that, you know, it's hard to coordinate everybody, but given that we have a little bit of time, I hope that's what we can do in this way. Thank you.
Councilmember Nishi? Oh, okay, so let's vote on the motion to postpone to January 21st, 2014. All those in favor say aye.
Aye.
All those opposed? Okay, so the motion to postpone and, yeah,
Move to adjourn.
okay. So all those in favor?
Aye.
All those opposed? Okay, this meeting is now adjourned.